Hi, YouTube. Legal Doug here. Let's take a look at another case. As usual, I am an attorney. I'm not your attorney. Nothing I say here should be taken as legal advice. You should always seek your own counsel. This is all presented for entertainment and educational purposes, informational purposes. But let's take a look at the case of Cohen v. California. It's a Supreme Court case from 1971. The case below originated in the state of California, obviously. The opinion was written by Justice Harlan, Justice John Marshall Harlan II. He was the grandson of an earlier Justice John Marshall Harlan. He was appointed by Dwight Eisenhower and generally considered a moderate to conservative on the court. In fact, let's look at the entire voting of the court on this one. As noted, Justice Harlan wrote the opinion. William O. Douglas, one of the most liberal justices during that period, I think, appointed by Franklin Roosevelt, joined in this opinion. William Brennan, another well-known liberal during that period of time, wrote some very important opinions, joined in the opinion. Potter Stewart, generally considered a moderate, sided with the liberal justices on this case. And Thurgood Marshall, another liberal on the court, also sided with Justice Harlan in his opinion. The dissent, it consists of Warren Burger, Chief Justice, appointed by Richard Nixon, a very conservative justice. Harry Blackmun, also appointed by Richard Nixon. And at this point in time, he was appointed in 1970, and at this point in time, he was still considered a conservative, but swung the other direction quite a bit in his later term. Also joining the dissent, Justice Byron White, more of a moderate conservative, appointed by Justice Kennedy. And then kind of a surprising one, Hugo Black also dissented on this one. Considered a liberal, and some people were surprised, I think, by his position on this one. There's some dispute as to whether he just disagreed with the reasoning on the opinion. He had a different reason for finding for Cohen in the case, or if he actually felt that way. I've done a little bit of research on that and have found different opinions on that. But that's the breakdown of the court. As always, I like to give you some context on who made the decision and why they may have been leaning that way. So let's take a look at the decision itself. So Justice Harlan delivered the opinion of the court. This case may seem at first blush too inconsequential to find its way into our books, but the issue it presents is of no small constitutional significance. It's freedom of speech. So yeah, he certainly seems correct on that. Appellant Paul Robert Cohen was convicted in the Los Angeles Municipal Court of violating that part of California Penal Code Section 415, which prohibits maliciously and willfully disturbing the peace or quiet of any neighborhood or person by offensive conduct. He was given 30 days imprisonment. The facts upon which his conviction rests are detailed in the opinion of the Court of Appeal of California, 2nd Appellate District, as follows. On April 26, 1968, the defendant was observed in the Los Angeles County Courthouse in the corridor outside the Division 20 of the Municipal Court wearing a jacket bearing the words F the draft. And I apologize for the ironic edit given the case, but I just wasn't sure exactly what YouTube would do with that. So bearing the words F the draft, which were plainly visible. There were women and children present in the corridor. The defendant was arrested. The defendant testified that he wore the jacket knowing that the words on the jacket as a means of informing the public of the depth of his feelings against the Vietnam War and the draft. The defendant did not engage in nor threaten to engage in, nor did anyone, as the result of his conduct, in fact commit or threaten to commit any act of violence. The defendant did not make any loud or unusual noise, nor was there any evidence that he uttered any sound prior to his arrest. So those are the facts as Justice Harlan sees them. In affirming the conviction, the Court of Appeal held that offensive conduct means behavior which has a tendency to provoke others to acts of violence or to in turn disturb the peace. and that the state had proved this element because on the facts of this case it was certainly reasonably foreseeable that such conduct might cause others to rise up to commit a violent act against the person of the defendant or attempt to forcibly remove his jacket. The California Supreme Court declined review by a divided vote. We brought the case here, postponing the consideration of the question of our jurisdiction over this appeal to a hearing of the case on the merits. We now reverse. So Cohen has won. Right off the bat, you see that in this case. Okay, let's take a look at Justice Harlan's opinion, the main discussion of it, section 1 here. So what he wants to do at first here is he wants to talk about, is this a case about the content of Cohen's speech, the word on the jacket, or is this something bigger than that? A lot of these First Amendment freedom of speech cases get into whether there are time, place, and manner restrictions around the speech that might be reasonable. Is it content specific or not? Is it content neutral, the statute that's being invoked here? And so that's Justice Harlan wants to get into a lot of what's not in play here in this case. In fact, the first paragraph, in order to lay hands on the precise issue which this case involves, it is useful first to canvass various matters which this record does not present. And so he talks about some of those things here. He says appellant's conviction then rests squarely upon his exercise of the freedom of speech protected from arbitrary governmental interference by the Constitution and can be justified, if at all, only as a valid regulation of the manner in which he exercised that freedom, not as a permissible prohibition on the substantive message it conveys. So then he walks through some of these different questions. In the first place, Cohen was tried under a statute applicable throughout the entire state. So is there a place restriction here? You can do that in general, but you can't do that in a schoolyard or something like that. He's saying that this statute is applicable everywhere. There's no place restriction on it. Then he says, in the second place, as it comes to us, this case cannot be said to fall within those relatively few categories of instances where prior decisions have established the power of government to deal more comprehensively with certain forms of individual expression simply upon a showing that such a form was employed. This is not, for example, an obscenity case. I think threats would be another thing that would fall into that category. He says this court also held that the states are free to ban the simple use without a demonstration of additional justifying circumstances of so-called fighting words. Okay, threats would fall into that. Those personally abusive epithets which, when addressed to the ordinary citizen, are, as a matter of common knowledge, inherently likely to provoke violent reaction. And that's where it's almost exactly what's in the Texas statute on disorderly conduct and incite violence type of language. And then he refers to an older U.S. Supreme Court case, Chaplinsky v. New Hampshire, which comes up in the dissent as well, which basically said, yeah, you can, in fact, inhibit free speech in that instance, and that it didn't take much in order for something to be considered basically fighting words. I think this court takes a different view of that. So while the four-letter word displayed by Cohen in relation to the draft is not uncommonly employed in a personally provocative fashion, in this instance it was clearly not directed to the person of the hearer. And that's a kind of a key point in this case. His statement on his jacket, that's not directed directly at, where two people on the street and one person uses that term in the face of another person, that's probably going to be considered more likely to incite violence than his statement on the back of his jacket that's just a general statement to the public. So no individual actually or likely to be present could reasonably have regarded the words on appellant's jacket as a direct personal insult. Nor do we have here an instance of the exercise of the state's police power to prevent a speaker from intentionally provoking a given group to hostile reaction. And then he says, finally, in arguments before this court, much has been made of the claim that Cohen's distasteful mode of expression was thrust upon unwilling or unsuspecting viewers and that the state might therefore legitimately act as it did in order to protect the sensitive from otherwise unavoidable exposure to appellant's crude form of protest. Boy, does that sound familiar these days. Of course, the mere presumed presence of unwitting listeners or viewers does not serve automatically to justify curtailing all speech capable of giving offense. While this court has recognized that government may properly act in many situations to prohibit intrusion into the privacy of the home of unwelcome views and ideas, which cannot be totally banned from the public dialogue, we have at the same time consistently stressed that we are often captives outside the sanctuary of the home and subject to objectionable speech. Like there's no expectation of privacy in public, there's no expectation of protection from the speech in public, he's saying. The ability of government, consonant with the Constitution, to shut off discourse solely to protect others from hearing it is, in other words, dependent upon a showing that substantial privacy interests are being invaded in an essentially intolerable manner. Any broader view of this authority would effectively empower a majority to silence dissidents simply as a matter of personal predilections. And then he goes on to say, given the subtlety and complexity of the factors involved, if Cohen's speech was otherwise entitled to constitutional protection, we do not think the fact that some unwilling listeners in a public building may have been briefly exposed to it can serve to justify this breach of the peace conviction, whereas here there was no evidence that persons powerless to avoid appellant's conduct did in fact object to it, and where that portion of the statute upon which Cohen's conviction rests evinces no concern, either on its face or as construed by the California courts, with the special plight of the captive auditor, but instead indiscriminately sweeps within its protections all offensive conduct that disturbs any neighborhood or person. So people are not trapped where they have to be subjected to this. They can avoid it. So in section 2, he goes on to say, the rationale of the California court is plainly untenable. That was the court that found against Cohen and found that he had violated the law. At most, it reflects an undifferentiated fear or apprehension of disturbance, which is not enough to overcome the right to freedom of expression. They're saying that the language on his jacket actually was fighting words, that it could invoke violence in some other person. Harlan says there may be some persons with such lawless and violent proclivities, but that is an insufficient base upon which to erect consistently with constitutional values a governmental power to force persons who wish to ventilate their dissonant views into avoiding particular forms of expression. The argument amounts to little more than the self-defeating proposition that to avoid physical censorship of one who has not sought to provoke such a response by a hypothetical coterie of the violent and lawless, the state may more appropriately effectuate that censorship themselves. In order to prevent some violent mob from reacting and stopping him from making the statement, the state's just going to do it. And they're saying that doesn't work. Harlan says the constitutional right of free expression is powerful medicine in a society as diverse and populous as ours. That's an important sentence. It is designed and intended to remove governmental restraints from the arena of public discussion, putting the decision as to what views shall be voiced largely into the hands of each of us, in the hope that use of such freedom will ultimately produce a more capable citizenry and more perfect polity, and in the belief that no other approach would comport with the premise of individual dignity and choice upon our political system rests. So, in summary, it is in sum our judgment that absent a more particularized and compelling reason for its actions, the state may not, consistently with the First and 14th Amendments, and you hear the reference to the 14th Amendment, so all that basically is saying is all of those restraints in the First Amendment on Congress shall not impose now apply under the 14th Amendment to the states, and that's what's going on here. With the First and 14th Amendments, make the simple public display here involved in this single four-letter expletive a criminal offense. Because that is the only arguably sustainable rationale for the conviction here at issue, the judgment must be reversed. Okay, that's the Harlan opinion. Not a lot to it. Basically, just saying that it's the word, the offensiveness of that word is just not sufficient to inhibit Cohen's free speech. He's not inciting violence with any particular individual, and we just can't be preventing people from making statements like that. It's clearly it's a political opinion that he's expressing in the way he's saying it. So if we now look at the dissent, which I think are also pretty light and not very substantive, but Mr. Justice Blackmun, again a conservative on the court, with the Chief Justice, who is Warren Burger, another conservative, and Justice Black, join. I dissent, and I do so for two reasons. Cohen's absurd and immature antic, in my view, was mainly conduct and little speech. He's saying that it's not the word, it's what he's doing is considered conduct. Further, the case appears to me to be well within the sphere of Chaplinsky v. New Hampshire. That's the case I mentioned up above, that where they found that, I think someone called some other people fascists, and that was deemed to be fighting words. So Chaplinsky v. New Hampshire, where Mr. Justice Murphy, a known champion of First Amendment freedoms, wrote for a unanimous bench. As a consequence, this court's agonizing over First Amendment values seems misplaced and unnecessary. That's his main point, number one. Number two, I am not at all certain that the California Court of Appeals construction of Section 415 is now the authoritative California construction. He refers to a case that's come along since then. Chief Justice Traynor, who was among the dissenters to his court's refusal to take Cohen's case, wrote the majority opinion. He held that Section 415 is not unconstitutionally vague and overbroad, and further said that part of Penal Code Section 415 in question here makes punishable only willful and malicious conduct that is violent and endangers public safety and order, or that creates a clear and present danger that others will engage in violence of that nature. It does not make criminal any nonviolent act unless the act incites or threatens to incite others to violence. I just, as an aside, my constitutional law professor in law school clerked with Justice Traynor. He was actually a very well-known California Supreme Court justice, particularly in areas of business and commerce. He had some very interesting, some would say progressive, opinions that he wrote in those areas. So that's the dissent. Byron White concurs only in that second part of the dissent, and not in the first. And that makes it makes it a 5-4 decision. And so that's the case. I would encourage people to read the footnotes in all of these cases. The footnotes in legal opinions are always very substantive, have a lot of information, a lot of background, and I would encourage people to read those, and I'll include those in the video. You can pause and read at any time. But that's an interesting case. It was conservatives against liberals for the most part. Might be a little different outcome these days, with conservatives more concerned about a left-leaning press and being able to get their opinions out there through other means, and maybe have a little different take on freedom of speech. But in 1971, that's how they lined up, and then that's how the use of profanity, is, so long as it's not obscene in public, is a protected free speech, according to the Supreme Court here in this opinion. So hope that was helpful. Again, try to be doing these on a pretty regular basis. Absolutely would welcome comments, and if you like it, give me a like, subscribe. If I could to continue doing this, I need to get that kind of support on this, and I hopefully will talk to you soon. Thank you.